much I listen to you. So I was board certified in construction litigation. I litigated for 18 and a half years in real estate construction law, argued to the Supreme Court of Florida, argued in every federal appellate court there was. But now I transferred the law firm. It's over to my brother, who then handles the litigation and the attorney side of things. I don't take on clients. This is what I do. I do compliance for the company, as well as you've heard, I am the Chief Happiness Officer of the company, so I act as a liaison between you and the company. So now let's talk about junk fees. So we're going to talk about the following things. We're going to talk about why are we talking about junk fees now, defining junk fees. We're going to give you examples of what junk fees are in title insurance transactions, and then we're going to go through some examples so that you get to actually have real life experience in spotting junk fees in your closing statements, otherwise known as alters or HUDs. I have to give you a disclaimer. Topics discussed here are general concepts. I'm not giving you legal advice. Blah, blah.
Yeah.
So this gentleman over here, he's the director of the Consumer Financial Protection Bureau, and on March 20, what was it? It was on January 26th, he asked every entity that deals with finance in the real estate industry. So he was going after mortgage, he was going after title, and he's looking to protect consumers that are getting targeted with what's called junk fees. So he issued an 8-page letter saying, please respond to this by March, because we want to know what type of junk fees are being consistently charged in mortgages and real estate transactions. And I will tell you, I am heavily involved in the American Land Title Association. I've been to California, to New Orleans, to Tampa, wherever they have their conferences. And I'm going to tell you, the American Land Title Association is heavily against the Consumer Financial Protection Bureau stepping in to try to regulate the amount of fees that are charged by title insurance companies. Oh, we regulate enough. We regulate enough. We've got the field. Don't come in. Well, I'm here to tell you there's absolutely terrible enforcement. We only have, that I know, there's only one person that enforces in the state of Florida against title insurance companies. It's just, there's a lot of us. In fact, we have more title insurance companies in the state of Florida than the entire country. You're laughing, but it's 100% true. And I found that out because I got an award that I went to, and they told me there's 6,000 title insurance companies in the country, but over 3,000 in the state of Florida. And that doesn't even include the law firms that are also doing title insurance. So, we're going to be talking, as I said, about junk fees. So, junk fees defined. So, junk fees obscure and distort the free market system by basically concealing the true cost of things. And I'm going to give you an example, and we all experienced it when we came here. And that is for instance, I gave, here's my, from the Marriott. I got a bill for $580 and then a resort fee. What do you mean resort fee? Isn't this all under one folio? What do you mean I can't go to the rest of the property? So this would be an example of a junk fee when I'm looking to see and compare, where should I go? I want the cheapest possible rate, but then I get surprised with this resort fee. I'll give you another example. I was in a Lyft. The Lyft charged me $9.13, and then I got a fuel charge of 55 cents. What do you mean? How do you transport me without using fuel? Shouldn't that necessarily be included inside of the fee? So these are examples of junk fees, things that you typically think would be included, they'd be covered in the transaction. You get unexpected fees for the products or services. It's fees why they're unclear that they were charged in the first place. Consumers are typically forced to pay these types of fees or risk being in default. I'm going to give you an example. I bought a property when I was it was in Brickell. It was the day of the closing, and on the closing statement there was a $100 FedEx fee. I said, what are you shipping, concrete? I said, I'm not paying $100 for FedEx. And they said, well, I'll tell you what, you don't pay that $100, then guess what? We're going to make a claim against your deposit. Not only are we going to make a claim against your deposit, we're going to sue you. We're going to claim attorney's fees. And you know what? We don't care if you do or don't, because we also represent the developer. So you're going to make our day. So I said, all right, fine. Well, I paid it. They actually shipped me the $100 back afterwards, but the point being is that's an example. And we're going to go through 20 examples just like that you guys are used to seeing and you've kind of just expected and you've accepted it, but they're not allowed. So I say that a junk fee is also, it's when you get a fee where it's commercially impracticable to do anything other than just pay. In other words, I can't afford to default. I'm not going to challenge your $100 and then risk being in default. It's just it's too much liability. The example that I give is it's like when you go to a restaurant. I say that you as realtors have been asking the wrong questions, and us as title companies have gotten smart. What is the question that the realtors are consistently asking? What's your settlement fee? What's your settlement fee? Okay, well, I know that she's going to ask, what's my settlement fee? So you know what? I'm just going to put it in another line item. So my settlement fee, oh, it's $4.99. Well, mine's $3.99. Well, mine's free. I'll just charge you elsewhere. So this is like, and people remember what they remember. So I give it like the restaurant analogy. It's you go there, you order the soup, you order the salad, and you order the drinks, but it's the bottom line that counts. It's how much did it totally add up to. It's all of the line items together. And I have a friend, his name is Howard, and he would always say at the end of every single time we went to a restaurant, I only had the soup and the salad. No, you didn't, Howard. You had the pork chop, the lamb chop, the veal chop, and everything else. And that's when the bill winds up coming. I looked up what's the most expensive restaurant bill I could find. But if you look at the top, it's not so bad. $39 for spaghetti. I mean, it's not bad. Not as bad as that. $47,000 by the time they get to the end. So, that was probably the one. If I had a guess. If I had a guess. Yeah. So anyway, the point being is it's the bottom line that matters. So if you all are just simply asking what's the settlement fee, you're missing out on the other questions that you should be asking. And so there needs to be transparency. So it's the settlement fee where the title insurance companies play a lot of the gamesmanship. This is where it happens. This is where all the fudging happens. Fudging? Oh, look at that. So watch for unusually low settlement fees. It is a virtual guarantee that if you have somebody that's offering you a low settlement fee, then there are going to be additional hidden fees. I'm here to tell you that there's no way for a title company to stay in business with a settlement fee of $4.99. It's an absolute bait and switch. I don't care what you call it. That's exactly what it's going to be. There will be charges somewhere else. And we're going to be exploring where are those other charges so that you can identify them and even challenge it. So let's talk about junk fees. We're going to go through 20 of them. Number one, did you know wire fees are junk fees? Wire fees are prohibited. You can't charge extra for wires. And by the way, if you're writing it down, don't. You don't have to. As long as you give me your card afterwards, I'm going to send you my article, which breaks these down and gives you the citation to authority. I'm used to writing appeals. I'm used to writing legal treatises. Trust me, it's that type of authorship. When I give it to you, you're going to be able to turn to things very quickly and then click on it, and I'll have the citation to authority on where this comes from. So most of this comes from the Department of Finance and Insurance. So the CFO from the Department of Finance and Insurance has addressed certain questions, like facts. Can I charge this? Can I charge that? For wire fees, I'm used to seeing companies charge $75. Well, the Department of Finance and Insurance gives one example of when wires can be charged, and I'm going to tell you it'll almost never apply. First of all, what they say is that wires can be charged to a buyer. Okay? Now, a buyer, it's not the buyer who's going to be wired money, it's the seller who's going to be wired the money. The seller gets the money. So what were they talking about here when a buyer can get money? When you'd wire money to a buyer, let's say that you have a buyer that has crap credit, and you have to pay off all of his creditors. Well, what they say is you can wire money for that purpose. And that's the only example they give, by the way. You can wire it for that, and then if you do that, it says as long as the agency did not add an amount to the charges from the provider of these services. So in other words, you can't upcharge for the wire. So I'm going to explain something further. So, and that's the one instance, and even then, they're saying you can't add anything to what it actually costs you for the wire. Now I'm going to tell you why. We don't charge for wires. This isn't a sales pitch for me. I'm going to tell you why we're not charging for wires. Because we can't figure it out. We don't know what our wires are until the end of the month. There's no way, because what happens is we have so much money in the bank that we get credits. And because of those credits, we don't get charged for a certain amount of wire. It used to be they were free, because interest rates are great. Interest rates are crap right now, so our credits are crap. So that means that it's not unusual that maybe our wire fees at the end of the month could be over $1,000. Maybe it'll be $500 if we have not a good month. But you know what? We don't know. We have no way of knowing. So there's no way to technically charge for it. Oh, I did. I switched to the next page. Didn't even know that. So anyway, moving on to the next one. Did you know about postage, mailings, and handling fees, FedExes? Like I said, I was really not happy when I got the $100 FedEx fee. Well, guess what? They specifically addressed this in 2 questions. They say examples of fees that should not be listed as separate line items on the form include, but are not limited to, postage and handling. There's another question asked. Can I charge a separate fee for postage, mailing, or overnight shipping? It says, it's supposed to be included in the closing service fee. What's closing service fee? That's synonymous with the settlement fee. We're going to be looking at things, but what they're saying here, again, all of this, that FedEx, in other words, what we're going to be looking at is the definition, and if you think, here's the easy way of thinking about it. If it's necessary and incidental to doing the closing, you can't charge a separate line item for it. It needs to be included in that settlement fee. Storage fees. Another word for storage fees that I see is warehouse fees, document retention, electronic storage fees. I don't know if you've ever been charged for getting one of those fobs, or maybe a CD, or a thumb drive. That's not permissible. A scanning fee, a printing, or copy fees. So I'm going to tell you why. First of all, it said it's prohibited. Once again, they address it specifically. But I want to tell you why it's so stupid that you have title companies or law firms that are even trying to charge for these archiving fees. First of all, there's this law that says that we have to retain certain documents that are included in the closing for 3 years, 5 years, and 7 years. So for all intents and purposes, we're not going to break apart a file. So let's just call it 7 years. So we're required to keep this for 7 years, and yet you have some companies that charge the storage fees. That's not right. Okay, the other reason is that if you're a law firm, you're a title company, you get sued because somebody's making a claim against the title, your defense is going to be, I throw it away, around the file. Of course not. It's stupid. Of course you can hold on to your file, and again, you're statutorily required to hold on to the entire file. So that's not permissible. Notary fees. All right, so typically, forget about closings for a second. We're moving on, okay, to not closings. And the typical scenario is $10 per notarial act for just a regular stamp. If you want to do a remote online notary, it's $25 per notarial act. Well, in a closing, that has to be included. You can't charge separately for those particular acts. Now, there is going to be an exception. We're going to talk about that. All right, the question was asked. Once again, examples of fees that should not be listed as separate line items, and again, this comes from the Department of Finance and Insurance, include but are not limited to notary services. Agencies that charge additional fees as separate line items may be found to be engaging in deceptive practices against Florida consumers in violation of the Florida statutes. Surprising, right? Well, now the exception for the remote online notarization is, and I don't want to get bogged down, I always get questions on this, I don't want to get bogged down, just accept it, or ask me afterwards. So, you may have remote online notarization only happened January 1st of 2020. The statute wasn't really that well written, there were glitches in it. So, the remote online notary companies kind of lobbied, and there was a change in like 2021, where if you're a remote online notary provider, like NotaryCam, Notarize, Pavaso, if you use a third party, then you can charge their fee. So their fee is like $150 typically, and so we do put that on there. Now we have remote online notaries in our office, but I'm going to tell you, you're going to be hard pressed to find a title insurance company that actually wants to do their own remote online notarization. And the reason is because it's a pain in the butt to do a remote online notarization. If you've got a mortgage, and you've got 100 pages worth of documents, and you have to sit there and what's called identify who the person is, and you've got to mark it up electronically. Who's notarizing, whether it's a buyer, whether it's a seller. It takes more time than it's worth. It's just easier to just simply charge the $150, let somebody else do it, and it's a pass-through. Now, once again, it's a pass-through. It's not something that should be upcharged. You're never going to see anything where I ever tell you that anybody's allowed to upcharge it. So the going rate for a remote online notary, $150. Now this was one of surprise to me, and I don't think that this is fair, but there is a way around it. And that is that what about mobile notaries? So we had a seller that was in California. Well, that's not our fault. You know, I understand if somebody uses us, they elect us, if we're not geographically reasonable to them, well, they shouldn't pay that. We'll pay the mobile notary. I get that. But what about when it's not our fault? The seller's in California. Why should I have to pay for that? Well, according to the Department of Finance and Insurance, you can't charge a separate line item for mobile notaries. So how do you do it? It's very simple. The title company simply has to increase their settlement fee. So let's say that the mobile notary was charging $150 as well. We're just using the $150. Okay, so instead of my settlement fee being $800, is now $950, but I cannot put this mobile notary as a separate line item. That's what the Department of Finance and Insurance is saying. Okay? It says it should be calculated in the closing service fee. Once again, it is impossible to do a closing without notaries. So it cannot be charged separately. The only exception is the one that's specifically written into the statute, which is the remote online notary provider. But again, that's not my pocket, that's theirs. Another thing that we're not allowed to charge for is recording service fees, escrow service fees. What I'm specifically referring to is I'm not talking about you can't charge for what the county charges for recording. I'm not talking about that. What I'm talking about is that I can't charge for the labor it takes me to do that. Okay? A title company can't charge and get inventive and say, well, it took me this amount of time to actually record it, so I'm going to charge a separate fee for it. No, that's necessary and incidental to the closing. You have to do that. The closing can't take place, once again, without this. Escrow service fees. Again, you have to escrow the money, you have to transfer the money, otherwise the closing can't take place, so therefore that is also a fee that cannot be included. And then you've got telecommunication fees like faxes and long distances that I wouldn't think would be included, but then again, I pulled up the last 8 closing statements that we had dealt with. I did this in March, and there it was. There was a fee for faxes. Upcharges, never. Can't upcharge. All right? Basically, I mean, it's like we're a fiduciary. So if there's a title commitment or a condo or HOA estoppel or a municipal lien search, which you guys never asked for, hey, can I actually have the receipt for that? We're not allowed to upcharge it. But I'm going to show you some things that you're going to be able to look at and you're now going to know, oh yeah, I was definitely upcharged, or at least you're going to be able to know, be sophisticated enough to even ask. Because you guys get upcharged all the time and you don't know. During the course of a closing, let's say that the closing takes place, we get the title commitment, all right, but the day we get the title commitment and the day of the closing, what if something happens in between that time period? That's called insuring the gap. So you're not allowed to charge for updates or recertification. So that time between the title commitment that's issued and the time that the actual closing takes place, if they try to charge you for any additional services for that, that's not permissible. Obtaining a mortgage satisfaction, as we all know, the mortgage satisfaction is not going to come the same day that you pay it off. In fact, there's a statute on it that they have to pay it off within like 60 days. If not, you can claim attorney's fees and all sorts of stuff like that. But you're not allowed to charge an additional fee for getting the mortgage satisfaction. That's a whole part and parcel. I mean, one of the conditions in your title commitment is going to say you have to pay off the mortgage, otherwise we're not going to issue title insurance. That's one of the things that I'm saying there. So of course, once again, that's necessary and incidental to doing the closing. Oh, this is also pretty interesting. Now, I don't know how many of you have actually seen this, but there's a law firm that does this. And what they say is what happens at the end of a closing, there may be some additional fees that we're holding because we held back maybe $250 for water, for utilities, for whatever it is. We don't know, but there may be some things that we have to hold back. So we're holding on to some money, and then we have to send the excess back, right? Well, sometimes it could be 10 cents, sometimes it could be $100, it could be the whole $250. So there's a law firm out there, and I'm only saying that because I've seen it, where they say if the amount is less, $25 or less, then we don't have to hunt you down. You waive it. It's our money. Well, the Department of Finance actually addressed this issue. They addressed this one directly, and what they said is that the title insurance agent or agency is not the owner of these funds. A title insurance agent, title insurance agency, or a title insurer is entitled to receive only the amounts listed on that settlement statement form for the services or products that the entity provided. Anyone that retains any portion of a fee that the consumer overpaid must refund that overage immediately. The Department of Financial Services does not recognize any waiver of the provisions of the Florida statutes that relate to funds held in escrow and or dispersed from escrow by a licensee. A title insurance agent or agency must immediately return any amounts that are due to the consumer regardless of the amount. 10 cents? Oh well. I gotta send it by certified mail. That sucks. It's part of the business. You agree to be a title insurance agent, you agree to play by their rules, right? Same way as you as realtors have. You got ethics under the MLS, you've got all sorts of EDGAR, and what's your statute, 471? Yeah. 475, thank you. There's so many licensing. So what else are we not, this is going to be the final one on this, and then we're going to talk about one more thing that I think you should know of, but really doesn't relate to title. And that is, so we're not allowed to charge extra for examining the public records, determining whether or not the property is insurable or not, evaluating a title search, clearing underwriting objections. Those are all part of your title insurance policy. But essentially, I'm going to break it down and make it super simple. Even though we went over these 20 examples, I'm going to come to another slide and we're going to make it real simple. Because really, there's only going to be 3 line items that you should ever see. So, again, this doesn't relate to title, but this is a charge that you're going to see on your closing statements. And that's for HOAs and estoppels. So the HOA, the co-ops, and the condos, their statutes are absolutely identical word for word for what can be charged for the estoppels. And the amounts that can be charged are, it's $250. It's $250 if the estoppel is provided within 10 business days. If it's provided within 3 business days, they can charge $350. So $250 within 10 business days, $350 within 3 business days. Now here, I'm gonna tell you, because this has happened and it sucks, HOAs are not nice people sometimes. There was an HOA where, well, let me tell you what it said. You add $150 if the client is delinquent. So there was a client that was delinquent, it was like $10. It was $3, it was $10, it was something astronomically low. It was terrible. They charged an additional $150. So you as great realtors are going to tell your clients, by the way, there's going to be an estoppel that's going to be ordered. And it's going to be a seller requirement, which means that you as the owner are going to have to pay for that. So if you're delinquent in any amount, you better get that paid, otherwise it's going to cost you an additional $150. Okay? So you're gonna let them know about that. Okay? So what are the 3 charges that can be charged? Well, one is the title search. This is otherwise known as a title commitment. So the title commitment, I'm here to tell you that title commitments are done by underwriters. They're old school attorneys do title commitments themselves, but basically a title commitment, all it is a checklist. It's culling the public records, and it tells you what's left that has to be checked off in order to convey marketable title. The underwriters have title plans, they have indexing that are much better than the counties, and this is what they do for a living. They ignore things that aren't recorded properly, or that have expired, or that have been satisfied, and they give you essentially a combined amalgamation of what remains left to be done. That's what a title commitment is. Okay, so now I've explained it. If you didn't know, that's what it basically is. It's a checklist. Okay, that's what a title commitment is. So the title search. The title search is charged, but it doesn't go into our pocket. That title search is actually 100% of that should go to your underwriter. All right, that should go to the underwriter. Like so, your Old Republic, your Stewart, your Fidelity, your whomever it is. That's where that money is going to. All right, so that should be. I'm telling you, the highest that I've ever heard that's legit charged by an underwriter is about $150, and that would be if you're doing no transactions a year, that they're not even happy to keep you as an agent because you're barely doing any business. Typically, the charge is anywhere $150 and under. Okay, our charge, what we get charged is $135 for a title commitment, so that's what we charge, and 100% of that goes to the underwriter. So this is a fee that you'll see, but it doesn't go to the title. It's not supposed to go to the title insurance agent. However, I've seen multiple times, and we're going to see, that you'll see somebody charging $200 for a title commitment. There's no underwriter out there charging $200. So if you wanted to ask your title insurance agent, can you provide me with the receipt for the $200? They're going to say, you know what, Closing services. So this is known as the settlement fee. This is where I said you guys are asking the wrong questions. This is where this is the fee that does go 100% to the title agent. That's where everybody plays the games. This is where there's a lot of fluctuation in the market. Our fee is $800 flat. I don't care if your price is $80,000 or $80 million. It really doesn't make a difference to us. It shouldn't make a difference. The amount of work that we have to do is independent of what the price of the property is. This is closing services, otherwise known as settlement fees, is essentially the labor it takes to do the closing. That's what it is. That's what a settlement fee is. And then you have the title insurance policy. The title insurance policy is the amount that's set by the state of Florida. You've heard about the promulgated rate. That's the amount that's set by the state of Florida. There should be zero competition with this amount because every place, no matter where you go, the price should be the same. Now, there is something called a Butler rebate where they're allowed to charge you the amount set by, everybody has to charge you the amount set by Florida, but they can't give the person paying for the title insurance back some money. So, but regardless. Is that me? All right. Well, I guess we're out of time, right? All right. All right, so I'll quickly point out, we're going to go through 8 closing statements, and I'm going to try to do it as fast as possible. Archiving fees, $95. Is this allowed? No. Estoppel, $347. Now, we went through the example, it's either $350, $250, or $150. Does any of that add up? Okay, so you're going to ask for a receipt. Makes sense. This is our charge, so we'll skip to this. This is wire fees. Are those allowed? No. FedEx fees, those allowed? No. Title search, something wrong with that $200? Should be, yeah, not too low, too much. All right, this, another thing that title insurance companies play games with, all right, because they make it look like they're not making much money. So what they'll do is they'll say the lender's policy and the owner's policy are going to the underwriter. It's not. Just so you know the business, we as title agents keep 70%, the underwriter keeps 30%. That's how it works. But regardless, this makes it look like this title company's barely making any money because they put certain things underneath the underwriter. Let's see. The other thing that you should know about a lender's policy, the amount that can be charged for the lender's policy is up to the amount of the owner's policy. This is also where a lot of companies play games because this lender's policy, like we always charge $400 for the lender's policy. But as you see here, the owner's policy is $2,825. So this lender's policy could be up to $2,825. So that's not, no, excuse me, that's an endorsement. The lender's policy is $250. So that's not bad. They're charging, they could charge up to this. Nobody really does that, but they're only charging $250. So this is another place where companies can get competitive is the lender's policy. Obviously, you're only going to have a lender's policy if there's a mortgage. This is something where I've seen kind of repeatedly. You've got a settlement fee and you have an attorney fee. So you've got $495 plus $1,000. So the settlement fee, this doesn't even make any sense unless the attorney is charging for some independent other type of work. You have, again, a title search, $200. Is that too much or too little? Right. Wire fees, $100. No. Yeah, not allowed at all. Again, you have a closing service fee and an attorney fee. This guy charged $2,500 plus $750. Not permissible. Well, these are the last 8 transactions that we did. Wire fees, $80. Settlement fee of $995. What about the scanning and storage fee? Is that allowed? No. Right. And then also watch for this, because sometimes they put it in a category that you didn't even look. This was actually, they put it under the loan charges as if this was mortgage. So it didn't look like this. Everything looked like this title company was charging was great until you actually looked in the wrong spot and found that they were charging all their fees. Fax fees, is that allowed? The estoppel. Now, I just want to point this out. The estoppel is $411.80. Now, as we spoke, that doesn't really make mathematical sense. But what happens sometimes is these companies that we order the estoppels through, if you pay by credit card, they'll charge you an additional amount, like maybe 2% or 3%. So let's just say 3% or 2.9% of $400. That's about right. So I wouldn't question that. $411.80. And thank you very much.